Welcome back to the Southern Scene on WSAV. It's time now for our legal scene. You know, recently the Supreme Court, as you know, effectively struck down the heart of the Voting Rights Act of 1965, freeing 9 states, mostly in the South, to change their election laws without advance federal approval. One side effect of the Supreme Court's decision, a possible flood of lawsuits, and that's what we're going to be talking to our legal expert Mark Tate about today. Okay, so Mark, break this down for us. I mean, the Supreme Court's decision on the Voters' Rights Act. I mean, break this down for our Southern Scene viewers.
Okay. So in 1965, we had this thing called the Voting Rights Act, and here's what it was designed to do. Obviously, all American citizens who are registered to vote have the right to vote. And there had been up until that point little tricks that some states employed and counties and cities employed to get it so that essentially African American people got tricked out of voting. They had things like poll taxes. The Voting Rights Act said that's illegal. Louisiana had literacy tests, and I've seen these literacy tests, and they were far more than literacy tests. They were unaccomplishable tests that were given specifically to African Americans because nobody could pass them, and it kept them from voting. And so the Voting Rights Act was an act designed by Congress and signed. It was a bilateral effort. Republicans, Democrats, everybody supported this. This was not a hard fight to win. And the President of the United States then, Lyndon B. Johnson, signed it into law, and it said that essentially there can be no discriminatory practices that serve to disenfranchise voters. And so they got rid of poll taxes, literacy tests, they got rid of hidden poll places, all of the things that have been done, they got rid of. So in the Voting Rights Act, there were several sections. One of the sections says that in states and counties which have been pre-identified as counties that are likely to employ discriminatory practices to keep people from voting, you got to get whatever changes you make to your voting laws passed by the Department of Justice. So, for example, all this business in Georgia of we want you to have a special kind of ID, that type of thing, all that had to get cleared.
Because all states are different. I mean,
they
have their own laws.
Have their own laws. Mm-hmm. That's right. And so it used to be that you had to get that pre-cleared, or Georgia, for example, would have to get that pre-cleared because Georgia had a 30-year at the time history of discriminatory voting practices. So they got rid of that. Now, the case came up before the United States Supreme Court, which allowed the Voting Rights Act to be reviewed, and the majority of the justices on the United States Supreme Court said that minority participation in the vote is so high, it's at record levels, we don't need the Voting Rights Act anymore, which is actually backwards, because the truth is the reason that minority participation
high is because it has been in effect.
Is because we've had an effective Voting Rights Act. So the day that the Voting Rights Act was stricken down by the Supreme Court of the United States, the various states that wanted to employ extremely restrictive voting rules went into action.
What do you feel will be the immediate practical consequences or the outcome of this?
Okay, so it used to be that if you made changes in the way people were allowed to vote, that there would be pre-clearance by the Department of Justice. That's gone. So now what will happen is people will there'll be changes to the voting, the way the voting is supposed to take place. And under Section 2 of the Voting Rights Act, people can still file lawsuits. There will be lawsuits filed.
And that's what I was going to ask you. Do you think we'll see? It seems like there will be a flood of lawsuits where this is concerned.
There's going to be a lot of lawsuits. They're not profitable lawsuits. They don't make a difference.
Now, when you say they're not profitable,
I'll never take one.
You'll never take. Now, why is that?
Because there's nobody who will pay me to do it, and there's no guaranteed. There's no payment at the outcome. We're just changing a law, and so it's got to be a public rights, public advocacy, pro bono group, ACLU, NAACP, Rainbow Push. These are the types of coalitions, ACORN. These are the types of coalitions which will be able to go out and raise money and hire and pay lawyers who are public interest lawyers who don't work for profit.
So let me ask you one more question. What would you like to see happen where this is concerned?
Well, I think that the United States House is going to have to take up the Voting Rights Act and reauthorize it and figure out how to create a system by which states can enact changes to their voting laws and have them approved prior to going in effect. Because what will happen is people will not vote. There will be people who are cut out of voting because of the changes that are made. And what I would encourage people to do is, if you're a registered voter now, when you go to vote next time and you're told you can't, vote a provisional ballot because litigation might change whether your vote counts.
That's good information. All right, thanks a lot, Mark.
Okay.
If you'd like more information on our legal expert, Mark Tate of Tate Law Group, all you have to do is go to the website that you see right there on your screen. And if you have a legal question for Mark, well, send us a message. And of course, we'll give you the opportunity to ask Mark anything that you want to on Tuesdays in our Talk to Tate on Tuesday segment. All you have to do is send us a message. You can find us on Facebook, The Southern Scene, or go to our website at wsav.com. Don't go away. We'll be back with more of The Southern Scene right after this. Stay with us.